All right, good morning. It is Friday, April 24th, 2026. We're here for the 9 a.m. docket. Case number 26-90103, Sachs Global Enterprises, LLC. Why don't we get appearances and then we can proceed.
Yes, good morning, Your Honor. Deborah Sinclair with Seacar and Gallagher for the Global Debtors.
Good morning.
Good morning, Your Honor. Bob Britton, Paul Weiss on behalf of the Zip Lenders.
Good morning.
Good morning, Your Honor. Lorenzo Marinuzzi. Sorry, that's...
Good morning, Your Honor. Betsy Feldman from Wilkie Farr and Gallagher, also on behalf of the debtors.
Good morning, Your Honor. Lorenzo Marinuzzi, Morrison Forster on behalf of the Official Committee of Unsecured Creditors.
Good morning, Your Honor. Jerry Lee Billick with the law firm on behalf of Simon Company.
All right. We're getting some background noise, so I'm going to activate the hand-raising feature, so hit 5-star if you would.
Conference muted.
Good morning, Your Honor. Jana Whitworth for the U.S. Trustee. I'm standing in for my colleague, Ha Wen, this morning.
All right. Good morning. All right. Any further appearances? Hit 5-star one time. Okay. From the 619 area code. All right. Ms. Sinclair, are you leading us today?
Yes, Your Honor. Again, for the record, Deborah Sinclair, Wilkie Farr for the Global Debtors. Your Honor, I'd first like to thank the court for its flexibility. I know we originally had this time scheduled for approval of our disclosure statement. We've had to move that hearing for a few days for a reason I'm happy to announce. Yesterday, the debtors, the ad hoc group, and the Official Committee of Unsecured Creditors reached an agreement in principle on a global settlement that we expect to resolve the issues of the UCC in this case. We do need a few more days to document that agreement, and we'll see Your Honor again for a hearing on the disclosure statement on May 1. We're expecting that hearing to be largely, if not fully, uncontested once this agreement is memorialized.
All right, thank you.
We still would like to use today's time to go forward with the Simon Status Conference, as well as the hearing to approve our exit financing commitment letter. If it pleases the court, I propose we start with the Simon Status Conference, and then I'll turn the podium to Ms. Feldman to address the commitment letter motion.
All right. Go ahead.
So we're proud to announce some more good news on the Simon front as well as we're driving these cases to consensus. We now have a deal with Simon, subject to definitive documentation. As you know, Simon is one of the company's largest landlords, so this is really great news. That deal is also supported by the ad hoc group, subject to the definitive documentation. That deal will resolve the litigation pending before the court regarding certain lease terminations, and it also provides go-forward solutions across the broader Sachs-Simon real estate portfolio, which is going to help better align Sachs's go-forward business plan and footprint. So we are working with the Sidley team to finalize documentation. We expect to file papers seeking court approval of the settlement under Rule 9019 within the next few days. We have, as I said, we do have the ad hoc group support subject to definitive docs. We've also shared the high-level terms of the deal with the committee. And I just want to note on the record that we'll continue to work with the committee as well to garner their support for the settlement. This is a deal that benefits all stakeholders because it's going to enable Sachs to continue a business relationship with one of our largest landlords and preserve value for the estate by cutting off litigation costs. So we'll make sure that the UCC sees all definitive docs as well.
All right. Good. Does anyone else
wish to
yeah, before we turn it over, does anybody else wish to be heard by way of an opening statement, if you will? Hold on a second. I just unmuted a 504 number.
Good morning, Your Honor. Jerry Lee Miller, Sidley Austin, on behalf of Simon Property Group. We just want to echo everything Ms. Sinclair said. We are excited to have reached a deal subject to definitive documentation, given that the docs are still, not signed yet, and there's, minor cleanup changes coming back and forth. We just request as a formal matter that the status conference be reset to Friday on the extremely unlikely event something happens, but we very much appreciate the debtors working with us here, and we're excited to have reached a settlement.
All right, we'll just carry it to next May 1st, which is, I guess, the next SACS hearing.
Perfect. Thank you, Your Honor.
And there's no need to we'll just make a notation on the docket. You don't have to file a notice.
Thank you, Your Honor.
All right.
Okay, with that, Your Honor, unless you have any other questions about the Simon settlement or the UCC deal, I would cede the virtual podium to Ms. Feldman to present the motion on the commitment letter.
No questions for me. Ms. Feldman?
Thank you, Your Honor. Good morning. For the record, Betsy Feldman from Wilkie Farr & Gallagher on behalf of the global debtors. As Ms. Sinclair noted, I'll be presenting the emergency motion for approval to enter into and perform under the new capital commitment letter, which we filed on April 8th. On Wednesday, we filed a witness and exhibit list, and we asked that the declaration of Mr. Baird in support of the motion at docket number 1967-2 be admitted into evidence. Mr. Baird is present in the virtual courtroom and available for cross-examination.
All right. Does anyone object to the admission of the declaration of Mr. Baird as his direct testimony in connection with this matter? It's filed on the docket at It's filed on the docket at 1862. And what exhibit number did you say it was?
It's exhibit number 2.
Okay. In exhibit number 2, does anyone object to the admission of his declaration as his direct testimony in connection with this matter subject to cross-examination? All right. Hearing no objections, it will be admitted.
Thank you, Your Honor. This motion represents an important milestone in these cases. As Your Honor may recall, earlier this month, the global debtors entered into an RSA with a significant majority of the ad hoc group. Concurrently, on April 1st, the global debtors entered into a commitment letter for exit financing, which is the subject of this motion. Together, the RSA and the commitment letter are the culmination of nearly 4 months of hard-fought negotiations for support for the global debtors' reorganization and emergence from Chapter 11. Today, more than 94% of the ad hoc group has entered into the RSA, and approximately 83% are signatories to the commitment letter. The commitment letter, as its name suggests, provides the global debtors with a commitment of up to $500 million of incremental new money financing upon emergence from Chapter 11. Unless the court prefers otherwise, I'd like to summarize the key economic points of the letter and briefly touch on the basis for the relief requested.
Go ahead.
Great. Thank you, Your Honor. So first, I'll start with a note about the form of the financing. The $500 million can take the form of debt or preferred equity. The commitment parties have until the earlier of May 15th and 7 days before the confirmation hearing to decide which form the financing will take. Second, I'll note the new capital commitment obligations.
Ask a question?
Yes, sir.
So if it's preferred equity, how does the ratchet down work?
What do you mean, Your Honor?
Well, apparently the $500 million will go down if your liquidity is in excess of $700 million at exit. And so if it's preferred equity, how does the ratchet down work? Maybe this is a question for Mr. Britton.
Yes, Your Honor. Again, Bob Britton, Paul Weiss on behalf of the DIP lenders. So I think it's the same either way, Your Honor. The minimum liquidity covenant is such that if the debtor's liquidity, which is a defined term of the formula.
Right, it includes ABL availability and all of that, right?
That's right. But to the extent it exceeds $700 million on the exit day, the amount of new capital that's put into the company would, be a reduction from $500 million, regardless of whether the form of that new capital is debt or preferred equity.
Okay. All right. All right. Sorry, Ms. Feldman.
No problem. Thank you, Your Honor. The second point is the new capital commitment obligations themselves, of which there are 3. the commitment premiums, and then customary indemnification and expense reimbursement obligations. I'll pause really quickly on the commitment premiums themselves, which are equal to 17.5% of the financing, totaling $87.5 million. The premium is payable in only one of two forms, depending on whether the closing date occurs, meaning not both the closing date commitment premium and the commitment cash premium. So with respect to the former, if the closing date occurs, the premium is paid in kind at the election of the majority commitment parties in the form of additional term loans or secured notes under the new debt facility, preferred equity of the reorganized debtors, and or common stock of reorganized debtors valued at a 20% discount to plan valuation. With respect to the latter, the commitment cash premium, if the commitments terminate or expire prior to the closing date, the company must pay the 17.5% premium in cash.
I understood.
The other point I'd like to pause on briefly.
Go ahead.
Is the administrative super priority nature of these obligations. Importantly, all three, the commitment premiums, the expense reimbursement, and the indemnification obligations are agreed to be treated as allowed administrative expense claims with priority senior to all other admin expense claims other than the DIP super priority claims. Mr. Britton touched on the excess liquidity reduction, which I will also note for the record. So this provision is designed to ensure that the global debtors do not draw upon the committed financing in excess of what is actually needed at emergence. It provides that the $500 million is subject to a dollar-for-dollar reduction to the extent the company's liquidity at emergence exceeds a threshold of $700 million. I'd like to note for the record that this provision is value neutral. To the extent that projected liquidity exceeds the agreed threshold, it is because the estates will have generated excess liquidity from their own operations, whether through asset sales, available exit ABL capacity, or cash on hand. In other words, every incremental dollar by which the funding is reduced is replaced by a dollar of independently sourced liquidity. This provision, I'll note, was particularly hard fought in two key respects. First, we negotiated for a liquidity threshold of $700 million, which was materially improved from early proposals. Second, the inputs for the formula for calculating liquidity were heavily negotiated. In particular, we negotiated for a waiver of the commitment cash premium if alternative financing emerges that the majority of the commitment parties consent to. Ultimately, Your Honor, we believe that this provision properly balances the global debtor's need for funding and the commitment parties' desire not to commit more funds than are necessary to ensure success post-emergence. As to the merits, Your Honor, I'd like to note 2 points. First, entry into and performance under the letter is a sound exercise of the global debtor's business judgment. Section 363B of the Bankruptcy Code governs a debtor's decision to enter into financing of this type and pay related obligations. The case law is clear that use of estate property outside the ordinary course of business in this manner requires an articulated business justification. We clearly have that here, Your Honor. This was extensively negotiated at arm's length and in good faith, and numerous written term sheets were exchanged and the parties held multiple meetings. As is the case in every negotiation, the global debtors did not get everything they asked for, but the commitment letter represents the best terms on which the commitment parties were willing to lend. The global debtors' proposed plan contemplates an equitization of the DIP lenders' DIP claims, and if the plan is confirmed, the global debtors will emerge with just $500 million of term debt or preferred equity on their balance sheet. Not accepting the terms of the commitment letter would put this agreement into jeopardy. Put differently, any alternative provider of exit financing would have had to be willing to commit enough cash to both refinance the DIP and also fund emergence from Chapter 11. In light of that, the global debtors weighed the risk that not accepting these final terms would have left them without a commitment for exit financing and no real viable path to reorganization. Ultimately, the special committee of the board, which comprises 3 independent members, approved the letter and the obligations under it. I'll note again, Your Honor, with respect to the administrative and super priority treatment, we believe that's warranted here because the new capital commitment obligations are an actual necessary cost of preserving the estate because they represent the consideration required in exchange for the funding commitment. In other words, Your Honor, the plan can't go effective without the aggregate funding amount. The aggregate funding amount can't be obtained without the letter, and the commitment parties would not enter into the letter without this treatment of their claims, or really any of the terms in the letter. Your Honor, I will note that the global debtors have not received any opposition to this motion, although the objection deadline was set for this hearing. So unless Your Honor has any questions, we would respectfully request that you approve entry into the commitment letter and its obligations.
All right. Does anyone else wish to be heard? All right. I don't have any questions. I did have an opportunity to review Mr. Baird's declaration as well as the motion. I do think under the circumstances this is a proper exercise of the debtor's business judgment. You know, the debtor came into this case very liquidity constrained. The biggest issue was the inability to provide merchandise for the stores. I think that the proposed funding and having liquidity in the hundreds of millions of dollars is a proper exercise of the debtor's business judgment, and I think it's a key cornerstone to this debtor being able to reorganize. So I will approve the commitment. So give me a minute so that I can. All right, that order has been signed and sent to docketing. Anything further we can do today?
Thank you, Your Honor. That concludes our agenda today.
All right, we'll be in recess, and we'll see you all next Friday.
Thank you, Your Honor.
Thank you.
Thank you.